Right here, there's a light on. Is the sound on?
He does. He does. Oh, I didn't know it was on the vegetarian. I'm not CPS doctor. I got some medications that Honorable John elevated. So only by the elevated weight or whatever. But students. That's good. I think that's great.
He was mad.
Yeah, I haven't been involved since the property was whatever, so I don't know. Just any difference.
Workers are leaving. I'd be out.
All right.
It's a big shit to turn.
Yeah.
Bob. It's the difference between actual stay and Wednesday stay.
Actual stay. That's
That's
days,
excludes
those holidays,
holidays.
weekends.
Oh, that's
That means, yes, this is literal, this is, and Dad called and said he can't be here. He has to work. But he said he could potentially be here for next Wednesday.
Because I want vacations for another 2 weeks, I guess. Well, yeah.
Looking at it.
Yes. No. We'll start in about 2 minutes, everyone. Good afternoon, everyone. It is Wednesday, June 16th, 2021. We're here for the detention hearings for the 323rd Judicial District Court of the State of Texas, Terra County's assigned juvenile court. I'll remind all the kids, this is a detention hearing. First, if this is your first detention hearing, the court will determine whether or not probable cause exists to believe that you've engaged in delinquent conduct. The law allows me to make that determination based on hearsay, and the court will utilize reports provided by the probation department based on the police reports. This is not a trial. This is not a determination of whether or not you actually did what you're accused of doing. It's merely, can I find, based on the police report, the essential elements of the offense and sufficient information to believe that you may have engaged in delinquent conduct. If you have information, either the kids or the family members, about the particular incident that led to your child's detention, I will ask you to forward that information to either the child's attorney or the probation officer, depending on what you believe is appropriate. I'll ask everyone in the audience today, please remember this is an official court proceeding. You're expected to be on your best behavior. This behavior will not be tolerated, and you will be excused without warning or forgiveness. The same goes for all of y'all. In addition, each of you has the right to remain silent, not say anything at all. Anything you might say during this detention hearing cannot be used against you in an adjudication, disposition, or modification hearing. However, we do have prosecutors in the room, and something you say, even though you think it might not mean anything at all, might lead the prosecutor to more information that they can use against you. Rather than just blurt something out, talk it over with your attorney first and advise him or her on what you want to say. That way he or she can advise you on whether or not you really should say it. Each of you will also have an attorney, and that attorney will be here to advise you during this process. As a convenience to the public, these hearings are being broadcast live on YouTube, as in keeping with the spirit of the open courts provision of the Texas Constitution. I'll admonish anyone who may be watching these hearings on YouTube that rebroadcasting or recording all or part of these hearings is expressly forbidden. Violation of the court's order may subject you to civil and/or criminal contempt. First on our docket is Hodder Razak Al-Bantari. Good afternoon, Mr. Gladstone. How are you?
Good afternoon, Judge.
Thank you, Mr. Lewis. Mr. Gladstone, this is an attorney-requested detention hearing.
Judge, I was in trial last week when he came up. I asked it to be set today. Generally, his father's off on Wednesday, but unfortunately can't be here. But Andrew's been in detention now for 151 days. Generally, he's been on one outstanding the entire time. His trial set in a couple of months, and I'd like to get him out on a electronic monitor. I basically need him out there talking to people, seeing if he can help with his case. The case against him is he was supposedly in a car as a Middle Eastern guy, and one of the victims on the case is out on bond, $25,000 for aggravated robbery. So if the victim can get out, I'm asking my client to get out.
All right, the court will take judicial notice of the fact that the court has previously determined that probable cause exists to believe that Mr. Al-Bantari has engaged in delinquent conduct. The court is also familiar with the underlying allegations, so will not reiterate them during this hearing. Mr. Reed, what says the state?
Your Honor, the state would object to the respondent's release from detention in consideration of this alleged criminal conduct for the safety of the community.
Mr. Lewis, it's my understanding that Mr. Al-Bantari has been level 1 outstanding since May 29th, is that correct?
Yes, sir.
So that's a period of about 18, 19 days, my math is close.
Yes.
All right. Mr. Gladstone, your arguments are not without merit. However, this particular respondent has prior referrals to the probation department, and given the gravity of the underlying alleged offenses in combination with that criminal prior history of referrals, it just gives me pause right now. I don't yet feel comfortable releasing him into the community. I feel at this time, based on history, that it would be unsafe to do so. So on that basis, I'll order him continue to be detained. Thank you, sir. All right. Mr. Alcazar Ibarra. Good afternoon, Mr. Bieber. How are you?
Good afternoon, Your Honor. Great to be heard.
Everything I deserve. All right. Ms. Lopez, what brings Mr. Ibarra to court today?
Your Honor, client was picked up after midnight on 6/15. He was driving.
After midnight.
Yeah. He was driving and the police officer could see he could not keep a lane. So he followed him for a bit, pulled him over, and the client showed signs of being disoriented. So he took him out, and client apparently did not pass it, and they searched the car as well and found some cocaine in the car.
All right.
So he was brought in later on after being fully checked. and he got here yesterday and checked it about 6 a.m. So he's
So
gonna be able to,
this is 131 in the morning,
in the Hearst area.
northbound on 820 near Hearst. Weaving in the roadways across multiple lanes of traffic, so the court will find that there's probable cause for the initial traffic stop. Court will further find that based on the additional information provided, that probable cause exists to believe that the child is engaged in some form of delinquent conduct. He's also on probation, isn't he?
Yes, sir, he's done 10 out of 12 months.
On UMD.
Yes.
Okay. Does he have his driver's license? Do you know?
He does not, Your Honor.
Oh,
All
right. So what are your thoughts, Mr. Beaver?
Yeah, I visited with Mr. Lopez as well as with Hayden's mother, and Hayden's mother would like him to come home on the electronic monitor. I know I've spoken with Hayden as well this morning, and he is attending summer school and would like to continue attending summer school, Your Honor. I know that this is a concerning allegation against him. I believe that he had been successful for the vast majority of the period of his probation, and unless I'm mistaken, was scheduled to be released next week. So we're asking that he be released so he can, and then also, unless I'm mistaken, the family is going to seek MHMR assistance as well. That was some services that he received in the past.
Thank you, Mr. Beaver.
Your Honor.
Yes, sir.
May I
Yes,
speak?
ma'am.
Client had an incident in the summer where his girlfriend was pregnant and they lost the baby. I think he started to lock himself in his room, and he should have reached out to re-engage in MHMR services, and he didn't. I mean, he needs to get back on his meds. Not, in all fairness, he did not stop taking the MHMR when them off of them. So I would like to see him get back, and if possible, on the monitor. I would only allow him time after school in his appointments. I've also asked for a drug assessment to make sure, because he really had not had a big problem before. I want to make sure that he stays clean.
I don't feel comfortable releasing you today. A couple of reasons. First, you're on probation. Second, 1:31 in the morning. 1:31 in the morning. Third, you don't have a driver's license. You know you're not supposed to be driving. And you're on for UMD, okay? And then on top of it, the drugs. That's a separate issue. But right now, I want to give you a chance to get stabilized in the back. Get to, you know the drill, get to level 1.0, and then we'll evaluate things, okay? All right, but it's only a no for today, all right? Thank you.
Thank you, Your Honor.
Mr. Ballard. You got a haircut, sir. Almost didn't recognize you. All right, Mr. Ballard, we met before. Sit up straight for me. You know the drill. You know I'm straight. All right. Mr. Jarman, why is Mr. Ballard back?
So he was court ordered to Grayson County on 170. He went to Grayson County on 121. In 145 days, he was at Grayson County. He received 35 incidents. Recent incident where he was restrained and allegedly assaulted a female staff. So Grayson County went ahead and unsuccessfully discharged.
All right, and based on that unsuccessful discharge, and he's previously placed on probation by this court by Judge Kim, is that correct?
Yes, sir. He was on probation for a criminal trespass that's set to expire next month on the 20th, and he was also placed on probation for aggravated robbery.
I thought there was felony there, but that was back in January, right?
Aggravated robbery was in January. He's on probation till 2023.
All right. And as a basis of him getting unsuccessfully discharged from Grayson County, y'all submitted a progress report. Judge Kim signed the DTA.
Yes, Your Honor.
That brings him here today.
Yes, Your Honor.
All right. Mr. Ballard, I will find that if I were to release you today, you would be a danger to the community. You knew that was coming up, but it's not a surprise. All right, we're gonna watch your behavior levels in the back. Let's go ahead and get a placement search started. And if we need an updated psych report, get my authorization to begin that process. And David, is there anything else we need to think of right now?
No, nothing I can think of.
All
I mean,
right,
I will say that his mother, I don't see her here today, she may or not, I don't know if she's here or not, but family was very supportive of him. He's got a close-knit family that could supervise him adequately, I believe, and I would ask the court to consider releasing him.
all right, not gonna do that today. We're gonna see how he does in the back. All right, thank you, sir.
Thank you, Your Honor.
Sincerely, Wilson. Yes, sir. All right, Mr. Richardson, what brings Mr. Wilson to court today?
Yeah, he was referred in custody very early this morning by the Arlington Police Department pursuant to a directive to apprehend that was generated by the electronic monitoring duty staff. He had a violation on Monday from 5:58 PM until 8:45. I contacted his family on Tuesday and talked to Dad, admonished him and Sincere to make sure that it wouldn't happen again. And then we had 3 violations last night, which generated the DTA. The underlying offense is assault bodily injury, where he was referred by Arlington Police Department on May the 6th, where their police were contacted and dispatched to a fight in progress. Officers met with the victim, who was bleeding from her hand and had some bruising on her face. She reported that she was approached by a group of 4 juvenile males, who she was able to identify. She identified Sincere as the person who punched her in the face and knocking her to the ground. And the other boys started punching and kicking her when she was down. The group of 4 is also alleged to have assaulted 2 other females who were attempted to intervene. Again, the report wasn't very clear, and how they located Sincere and brought him. He was taken into custody and brought to us. He was subsequently released at that detention hearing. Monitor. That brings us to the point we are now. There was a drug test that he was asked to take yesterday, and he refused to produce a sample.
All right. Based on your refusal, I'm gonna find that you may be positive for marijuana, cocaine, opiates, methamphetamine, amphetamine, hydrocodone, who knows what else. Judge Kim gave you a chance. I'm not gonna give you a chance. I'm gonna order that you detain. I'm also gonna find, based on Judge Kim's previous determination that probable cause exists, that you believe that you engaged in delinquent conduct, that continues to be the case. I'm gonna order you be detained. We're gonna see how your behavioral levels go in the back. You need to get to level 1 outstanding and hold it before I will even consider you for release. All right, you're not level 1-0, I will not consider you for release, all right? Susanna Faith, is it Celestino? Am I pronouncing that correctly? Good afternoon, Ms. McGonigal. How are you?
I'm good, thank you, Judge. How are you?
Ms. Thomas? All right. The court's previously found that probable cause exists to believe that you engaged in delinquent conduct. You know what I'm going to ask you, right? What's your level in the back?
3.
Yes, ma'am. What does it have to be before I can consider you for release?
1.
Yes, ma'am. And it's not, is it? So what do I have to do?
Detain.
Yes, ma'am. Ms. McGonigal?
Your Honor, I think there may be some circumstances that would explain her behavior. At the last detention hearing, Judge Kim actually ordered her to the custody of DFPS.
To what?
The custody of DFPS, CPS, that did not happen. You're supposed to assume custody today. Based on the offense report that you have, Susanna has a history of CPS custodianship. I think the unknown, the uncertainty about what was going to happen this custody time kind of made her a little anxious in the back, and so she just wasn't sleeping well and didn't get up to get to the program. It wasn't as though she was in bad level 3 causing problems, it was just more the uncertainty of the present situation was what was causing that. So I would ask the court to reconsider the decision, knowing that her behavior level is not because of malice on her part, but more just uncertainty and anxiety.
All right. at the time that CPS is ready to take custody, I'll allow you to have an attorney request a detention hearing, and either Judge Kim or myself or Judge Terry will consider that. But as for today, I'm not gonna authorize your release. You need to get back to level 1 outstanding, all right? Thank you. That'll be the order of the board. Janai, Monet, Corinne. Is it fair to Corinne? Corinne? Yes, sir. How are you, Mr. Spence? All right, Ms. Moran, the court has previously found a probable cause exists to believe that you've engaged in delinquent conduct sufficient to warrant your initial detention. So I won't go into the underlying facts of your detention. You've been level 1 outstanding since May 21st. That is not easy to do. Congratulations. She has a hearing before Judge Terry next week. Is that correct? And she is on the waiting list, correct?
Yes.
Okay.
We're looking at, she's on the waiting list for care house. She's indicating that she does not want to go to care house. They told us today that they can probably get her in next week. She's also, they're looking at the Methodist home in Waco for her too.
Okay.
They would like, the Methodist home would like to see a copy of her site that we have. So we just need to get it released and send it to them.
All right. If you'll present that to me, I can prove that. Do you object?
No, I don't.
Okay. Then with council's agreement, if you'll present me with an order, I'll allow that. She also has a lengthy history of runaway, doesn't she?
She's just not staying at home. CPS is involved. CPS is supposed to be here today, but they didn't show up, so.
You've been level 1 outstanding for a long time. And I will look you in the eye and say congratulations and thank you. Because I know the group of girls back there right now, that's not easy to do. Thank you for being a role model for everybody else back there. I sincerely mean that. Because you're doing all the right things. Unfortunately, your history of runaway kind of gives me some pause. But you continue, have you been talking with your attorney? Okay, well, she's able to call you and you're able to call her. So when y'all call each other, tell her how things are going. Talk to her about what you do like and what you don't like about care house as a possibility or about the other options. Talk that over with her, okay? Because that'll tell her how she can best help you. Does that make sense? All right. Have they been allowing you to contact her when you tried?
Yes, and there is a family that she has mentioned, she's also more interested in going with other than replacement. So we haven't had much discussion on that. And with her history of runaway, I think I want to explore that option and see if that would make her stay put. But that's something I'll have to discuss with the family and see if that works.
Well, it's a hearing before Judge Terry, I guess, next Tuesday. So you might want to have those ducks in a row so that Judge Terry is in the best position to make an informed decision. So, all right, thank you. Keep doing what you're doing. As for today, just based on your history of runaway, I have to order that you be detained. But keep doing what you're doing, okay? Thank you.
Thank you, Your Honor.
Thank you, Mr. Spence. All right, Everardo Macias. Oh, thank you. Okay. Mrs. Rojas.
Mr. Adler here today?
He is not. Thank you. All right, Mr. Rojas, the court has previously found the probable cause of this to believe that you've engaged in delinquent conduct sufficient to warrant your initial detention. The court is familiar with the underlying allegations as well as the fact that the grand jury has approved this case for a determinate sentence option. You've been level 1-0 for the last, what, 5-6 days? Is that correct, Mr. Ross? Given the gravity of the underlying allegations, not just the offense that's alleged, but the facts that are alleged in the police report about the planning that went into this specific incident, the court does not feel safe releasing you this time. It's way too serious, this type of serious offense. The court taps the brakes, and it takes a little longer to convince me that you won't be a danger to the community if you are released. The only way you can convince the court is by maintaining level 1-0 in the past, like you're doing right now. So I want to encourage you to continue to do that. But at this time, I just don't, given the underlying offense itself and the specific allegations, I don't yet feel comfortable releasing you. So I'm going to order you to be detained. Thank you, sir. Thank you, Ms. McCoy. Yes, ma'am. How are you? All right, Ms. Willingham, how are you? All right, Ms. Willingham, the court has previously found that probable cause exists to believe that you've engaged in delinquent conduct sufficient to warrant your initial detention. She's already on probation, is that correct?
Yes, sir.
All right, Ms. Willingham, you know what question I'm going to ask you. What's your level in the back? 2, right? What's it need to be before I can consider you for release? All right, what are you going to do between now and the next time we meet? Get to level 1-0 and hold it for me. Well, that's real vague. That's real vague. Give me specifics. Okay. All right. As for the day after, order you be detained. You understand that, right? All right. Thank you. That concludes today's hearings. Thank you, everybody. All right. Kathleen Zhang, hold up. Sure. All right. What you got, Ms. McGonigal? We're no longer broadcasting, so. What you got?
I thought that I had told you that CPS was supposed to take custody of her today for Judge Kim's order, but my client, probation officer, said I didn't say that to you. So I'm gonna take 2 people over my statement. So Judge Kim did order her to be picked up by DMCA today. So they're here. They've been present for the detention hearing. I would ask that she be released to her custody. She's been in detention longer than she should because mom has not wanted to take her home. And that's meaning she's in detention. And so her level, like I mentioned earlier, as probably her level is not level 1 today.
Can I say something?
Yes, please.
We had not, the mom is not able to talk to us because of her attorney. We're just now getting to talk to her and find out everything that's been going on. And we have done all our due diligence at this time. I think we will once we finish talking to mom, but a lot of pieces were missing.
So y'all aren't willing to take?
We'll do whatever you want to do. Right now, we don't have a placement.
Well, she's decompensating him back. And anything that y'all can provide her is probably gonna be better for her long term than spending another 2 weeks here. So how much time are we looking at?
To find a placement.
Yes, ma'am.
What's today, Wednesday?
Yes, ma'am.
I will start working on it today, realistically, probably Monday.
Mrs. Gospel, what are your thoughts?
Your Honor, I would ask that she be released now. She was actually ordered in DFPS custody 2 weeks ago. After that order was made, it then becomes, oh, she's away from psychological on the 15th. She was supposed to be ordered today. There was some mention that she might have been, that she was supposed to be picked up this morning, but that wasn't concrete. I don't think it's fair to Susanna to be penalized because there's all different agencies involved and no one's talking to the other and not doing their job. As you mentioned, she is decompensating right now, attention, and she should have been home almost a month ago.
May I add, Your Honor, as the liaison?
I can't,
Oh, I'm
I'm
sorry.
curious
May
as
I
to answer.
add, as the liaison, in reference to the young lady, in order to find her the best possible placement, they're gonna start CPS can start looking today, but we really would like to find a placement that would best suit her needs instead of taking her to the office and letting her sit in the office, because that's not gonna be beneficial to her either.
All right, this is the very same discussion that we had with this court 2 weeks ago on June the 2nd.
Yes, sir.
All the very same discussion.
Yes, sir.
It sounds like we haven't moved along since then.
And Your Honor, I think partially, a lot of that was due, Mom retained an attorney and CPS was not allowed to speak to her. She would not provide any information. They had no information to work with, no history, background, or anything. Today, I believe she is willing to speak, but they've made attempts to speak with her, but her attorney would not allow it.
He literally would cut her off when they were on the phone together and tell his client to stop talking.
CPS was actually contacted about 22 days ago. This didn't just start on June 2nd.
That is correct, Your Honor.
Addition. Records yet?
We just now, we're trying to get them. We've
So that's
requested
a
them.
no, y'all
No,
don't have
no,
the Iowa records yet.
not in our hands, not yet.
So in the last 30 days, okay, come get this child.
Okay.
Today.
Okay.
She had any history of drug use?
So for your English claim that you came in, it's been well over a year here in Madison.
Okay, but no indication?
No.
All right.
No.
She's yours.
Okay, thank you, Your Honor.
I'm sorry,
That's
but
okay, we appreciate it, thank you.
her mental health is gonna be better with y'all than it is back there, especially with that group of girls that's back there right now. And
Okay.
I have to take that into account.
Yes, sir.
Just trust me on this one, Ms. McGonigal. Ms. Thomas, they both know what I'm talking about. There are about 3 girls back there. It's not gonna go well for her. So, yeah,
Thank
this
you
is
very
better
much.
for her.
Thank
I
you.
appreciate it, thank you.
Ms. Thomas, thank you. I'm sick, Ms. Godwell, seriously.
I know you had some different pieces to the information and the.
I could have sworn I said that, already, but 2 people said I did, so I'm gonna take them as your word.
Oh, well, I didn't know. I thought I shut it down.
I don't know how to turn it on or off.
Just want to throw it out there, so it's still.
Oh. Now is it? It should be shut down now. There was one more window.
Sorry to bring that to you after the fact that I apologize, I thought I had mentioned it, but 2 people said I did, so I'm gonna take them at their word. I apologize for not mentioning that when I did speak earlier. Yeah.
No, thank you for stepping up and, hey, wait, there's more here. Thank you.
It's an ongoing problem lately with them. Well, yeah, it's ongoing. So we're gonna look for another, relatively good news. Okay.
Oh, there it goes.
Okay.
Okay.
And Judge, will you sign this one for me, please?
Yes, ma'am.
Nope, no, it was just, it's still going.
Okay.
Turn it off.
How many windows does he go in? Oh, wait.
I'm sorry, I'm